Hi, a very good afternoon to all of you, and welcome to EPLI's HR and Industrial Relations webinar series. Today, we'll discuss on the topic of retrenchment, the art and science of retrenchment. Well, we are back in CMCO again, and given the current state of COVID-19 cases, the CMCO will continue till December 6th. A lot of businesses are affected with the CMCO, despite the fact we are able to operate under 3 guidelines and SOPs. We had witnessed businesses that were able to withstand the first MCO and CMCO. But the second CMCO we are going through now is taking a toll on businesses. Our discussions with many of them reveals that they are taking serious steps to downsize their businesses as well. And as per latest news on Wednesday, it shows that some 30,000 companies, including micro businesses, have shut down. And also, as reported by the Department of Statistics, our unemployment rate is sitting at 4.6% as at September and October 2020, compared to 3.2% the same time last year. As at October 28, 2020, SOCSO announced that a total of 90,000 people have been laid off or retrenched based on the number of EIS applications. Some of the major names announcing or announced VSS or MSS or even retrenchment are the likes of Malaysian Airlines, Asia, Malindo, Park Royal Kuala Lumpur, Equatorial Kuala Lumpur, Kenting Group, Media Prima. These are the big names, but there are hundreds and thousands of SMEs who are also undertaking similar exercises. With this in mind, we undertook the decision together with our associates and partners to organize this webinar to educate and equip employers and businesses with the knowledge or know-how to handle the employment separation matters professionally and legally, at the same time in a fair, just, and humanly manner. With me today, I have 2 panelists and 1 guest. My first panelist is Dato' T. Tawalingam, the managing partner of T. Tawalingam & Co. He is held in high esteem in the field of employment. Dato' Tawa has earned tremendous praise among peers for his extensive knowledge. Dato' Tawa handles both advisory and litigation matters in the context of labor and employment law. Clients describe him as quick, accommodating to clients, and very solution-driven. He has been involved in some of the more significant high-profile employment disputes in recent Malaysian history. A highly visible figure in the market, he has authored several publications and has been rightfully acknowledged by Euromoney as a leading labor lawyer in the country. Welcome, Dato' Tawa. Mr. Daman Sibalingam, the managing partner of Daman Sibalingam & Partners. Daman has commenced legal practice in Zul Rafiq and Partners before joining Federal Auto Holdings, where he was responsible for all IR and legal matters for the companies within the group. Daman moved to work in Shell as their employee relations and industrial relations manager, and subsequently joined Mecca Employers Consulting Agency. He is now the managing partner of Daman Sibalingam & Partners. In total, he has more than 20 years' experience in handling industrial relations and labor matters in Malaysia. Welcome, Mr. Daman, and these are both our panelists. And we have got a special guest today, Mr. Sukdev Siritaran, who is the CEO of EPLI Asia Sinar Berhad. Prior to EPLI, Sukdev was the Group Senior General Manager of a public listed company in Malaysia, leading the corporate turnaround of their Human Resource Department as well as the Resource and Education Division for the company. He has more than 25 years of experience in senior management roles in various companies across the education, automotive, hospitality, property development, and human capital development. We'll start our session with the general understanding of retrenchment and moving into the actual process within the organization, where Mr. Daman will cover the scope. And what happens in court if this case is being referred to the industrial court will be covered by Dato' Tawa. And we'll end our session with a Q&A. You may post all your questions in the chat group, and I'll address the questions with our panelists. As we all know, retrenchment can be a tricky thing to do. Over the years, we have seen many employers or businesses make mistakes that results in unfair dismissal claims, a very messy and costly affair. Often these mistakes made even by employees who have done their research on the law, and sometimes even by those who have obtained legal advisement but allowed emotions to take control. Knowing how to properly carry out the exercise and knowing the practical mistakes and missteps to avoid comes with experience. And today we have two specialists with vast experience not only in consulting on this subject matter, but also representing employees in the industrial court. Welcome, Mr. Daman and Dr. Tawa.
Hi. Good afternoon, everyone. Yeah.
Okay, good afternoon, gentlemen. Can we kick off right now? Okay, we'll start with the general understanding of retrenchment in the Malaysian context of it. So I'd like to pose my first question to Mr. Daman, okay? You know, the word retrenchment, layoff, and redundancy has been used interchangeably. So can we have an understanding in the definition of the three different terminology that is being used so we can really differentiate what it really means in the context of the legal perspective? Mr. Daman?
Thanks, Supra. Good afternoon, everyone. Good afternoon, Dato. You're right. You're quite right in that loosely, HR practitioners tend to use these words interchangeably. And I've had a small sneak peek in Dato's slides. So and he's going to cover the definition of retrenchment in quite detail. So I'm going to steer clear of that. But typically, redundancy is the reason why an employer resorts to a retrenchment. So redundancy is a state where the position or the role is now no longer required because something has happened, rendering it irrelevant or unnecessary. For layoff, however, if you look to the Employment Termination and Layoff Benefits Regulations 1980, and I know this, I'm starting this off quite technically, but layoff is specifically defined in those regulations as a situation where an employer does not provide work for an employee for at least a total of 12 working days within a period of 4 consecutive weeks. And I think that's the important aspect from a legal perspective, meaning to say layoffs are not permanent, unlike a retrenchment caused by redundancies. I would like to qualify, however, that the Termination and Layoff Benefits Regulations, when they talk of the word layoff, it has a qualifier there where it says it only applies to employees who are hired on contracts where they get paid only if they are provided work. And this was confirmed in the High Court case of Viking Ice Cream, which says that it doesn't apply to continuous or permanent employees, but rather employees who are on a day rate. So I think redundancy, which leads to a retrenchment, is a permanent termination of the employment contract, whereas layoff, as defined in Termination and Layoff Benefits Regulations, is where someone is not provided work for at least 12 days in a period of 4 consecutive weeks, and thereafter they come back and get work. I hope that sort of helps answer the question. You're muted, Supra.
Gotta tell him.
Okay. Can you hear me now? All right. Okay. Right now, going back to our topic on retrenchment. Okay, retrenchment is a form of dismissal, and I understand technically there are two types of dismissal. One is the voluntary, and one is involuntary dismissal. Right. So I would like to seek Dr. Tawa if you could give us a more detailed explanation with regards to voluntary and involuntary separation.
Sorry, Subra, when you talk about separation, yeah, because a voluntary separation is basically when the parties, both parties, the employer and employee, right, they agree to part ways, and this basically sort of precludes any litigation because there's a meeting of the minds, right? They call it suka sama suka. I pay you something, you go, in simple language. So that's a voluntary separation. But if you look, and I think Brahman will agree, if you look at recent statistics, there are a lot of cases where employees have taken the separation and still challenge the employer in court, saying that it was involuntary. So the documentation shows voluntary separation, but the argument later is it was done involuntarily. So you have the paper trail. They file a Section 20 at the Industrial Relations Department, seeking the remedy of reinstatement. And of course, the employer's argument is you parted ways voluntarily. There was no termination. There was no separation. There was no dismissal, right? But they argue I was actually forced into it. I had no choice. So there are a couple of cases. There was a recent Serium case which I did. We were successful there, where a group of employees took the voluntary separation, but they later argued that they effectively had no choice, because to them they thought that if they didn't take it, they would be dismissed. But this is where I think the paper trail is crucial. How you present the documentation, both at the end, the final document, and the sequence of events leading to that. So if it's a voluntary separation, right, effectively the aggrieved employee will not have a cause of action. And if you look at the current situation now, the minister still, right? The minister still has the discretion whether to refer, because there was this proposal initially to refer all matters directly to the industrial court the moment there's a complaint. But now the minister still possesses that discretion whether to refer. And in my view, in a simple, straightforward case of a person taking a separation package and leaving, the minister would be quite right in not referring the case. So there's that filter there. But again, the process is very important. So that's the separation which is done by mutual consent. Then of course the direct dismissals are through, a retrenchment, because a retrenchment is effectively a dismissal, right? In Malaysia, a dismissal would include a dismissal for misconduct, poor performance, and redundancy. I call it the PMR thingy, right? Performance, misconduct, redundancy. So each has its own rules and little guidelines that you have to comply with. So if there is a dismissal, if the employee is retrenched, right? So employees say, listen, I've paid him retrenchment benefits. I've complied with the process, right? I've notified the labor department, right? So what have I done wrong? But we must remember the employees or the aggrieved employee's constitutional right to challenge if he or she feels that the retrenchment process was not right and he or she ought not to have been retrenched, the job is still there. They have a right and a recourse to the Industrial Relations Department. You okay with that?
Yep, thank you. Okay, in this situation, Dato, and this are open to Dato and Mr. Daman, right? Given the options here in an organization, okay, would I take the voluntary options of issuing a VSS, or would it be safer for the organization to straight go into a retrenchment exercise if I really need to downsize my business?
You see, can I just before Daman, because of course Daman has the advantage Daman has, unlike me, he has worked in institutions and has actually been in operations before coming into practice. So of course I'll leave the later part to him. I'll answer the easier questions. I'll answer the easier question. The easier question here is, to me, in order to execute a successful voluntary separation, you must have money, right? If you have no money, how are you going to entice the employee? Because the separation exercise basically is you trying to entice the employee to go in a happy way. I give you some money, I recognize your services, and you take the money and you don't sue me, to put it very crudely, right? So if you don't have the money, so most companies are actually suffering from, financial losses, etc. So when you don't have the funds, how on earth would you be able to execute a good and effective voluntary separation? And the employee will always compare what they have and what you are putting on the table, their rights. So they look at their contract of employment, especially those who are unionized or whose contracts actually provide for retrenchment benefits or termination benefits. So if they come within the scope of the Employment Act, it will trigger the termination benefits under the regulations, 1980 regulations. If they are unionized, the collective agreement will, in some cases, provide for that. Then, of course, senior management, their contracts are silent on retrenchment benefits, so there is no obligation to pay. So when you put up a MSS, right, there must be some kind of a carrot to attract the employees to bite. If they say, listen, why don't I don't take it because it's less than what I would be contractually or legally entitled to if I was retrenched. You're giving me, say, X amount, but if I was retrenched, I'll get X plus Y plus Z. So go ahead and retrench me, right? So that is my. But okay, anyway, Daman, maybe you want to take on that and see what.
Yeah,
Yeah.
I think that's all. Yeah, that's all completely right there. Because typically, if you want a VSS or an MSS to be successful, it comes down to the dollars and cents. And it's challenging to go up to someone without a reason, but to tell him, I want you out, which is essentially the message. And what makes the challenge go away is the enticement. And if you're in a situation where you don't have the financial backing, it's going to be difficult to entice. But of course, if assuming you had the resource, from a legal standpoint, a VSS gives you more cover from an employer's perspective compared to a retrenchment. If it's done voluntarily, the package is right, like as that we mentioned, suka sama suka, with the right amount of enticement, you have the money that should give, and with a proper documentation trail, from an IR perspective, you are sort of covered from challenge. Whereas retrenchment, even if the package is good or whatever, anyone can challenge because you did not get my consent. So to answer your question, from which would pose less IR repercussions, definitely a VSS. But it comes down to how that conversation is held, what kind of a package you can offer. Again, people will expect more than market for retrenchments if you're going to go down the route of the MSS. Anything that you are trying to be equal or even less, it's a waste of time.
From your experience, what would be the market average for a VSS or MSS? That I'm sure it's not written on stone or it's not in the law, right? But
Yep.
From your experience, what's the market average is going for?
Yeah, I will start by saying that it's possibly the most well spread rumor in amongst HR, amongst employees, that I'm entitled to 1 month for each year of service. So to me, a VSS has to be upwards of that.
Okay.
The more it's higher from 1 month, the better.
Okay. So even if I have offered say 1.5, 1.75, yeah, that you got some.
So, taking from where Daman stopped, because even when you talk about industrial court proceedings, when the court decides not to award reinstatement, because the primary remedy is reinstatement, but the court decides not to award reinstatement, the formula that they adopt is 1 month for every year of service. So that has basically set that benchmark for employees to look at. And of course, Daman will tell you, because he has been involved in a number of major restructuring exercises, which I have also worked together with him. So he will tell you that there are times where we also have to work out, because the length of service is crucial, right? So you've got a person who's worked 2 years, one person has got 20 years. Do you say 1 month for every year of service? So the guy has worked 2 years, he gets 2 months, he's not even going to bother looking at the form, right? So there are times where, and then the person has got maybe a year to retire and he's got 20 years service. Do you pay him 20 months or do you allow him to retire? Because he's only got 12 months service before he retires. So he would want the VSS because he's going to get 20 months, right? And again, I think, we all talk about the law and the legal ramifications, but there are times where I think people like you guys, like the HR guys and the consultants, have to come in, because we all forget that we are dealing with human capital here, right? It's not the dollars and cents. The dollars and cents attracts, but there are times, I think Daman and I worked on some of the major restructuring of airlines, and when we did when a VSS is offered, it's also how you manage. I had one case where it was poor articulation of the exercise. When the employee applies for a VSS, right, and the employer replies saying duka cita dimaklumkan, it's like you're not selected. So he thinks it's the end of the world. He's devastated. But in fact, you are actually giving him a lifeline. You're saying, listen, I still want you. You still got a job. So there's some organizations, they mean well, but again, inelegant choice of words in the course of replying. So it's very important that you need to get the right people. I'm not saying that you must go and get HR consultants, but your IR people must be able to, it's actually effective communication. The law is one thing, the finance is one thing, but if you can't communicate, I had one case where the guy got rejected, who was VSS, was not accepted. He became a nuisance in the organization because he felt a failure. He kept appealing, saying, I've actually planned to do a business. You have deprived me of my livelihood. And I said, what do you mean deprived you of livelihood? You got a job. But he's looking at that financial consideration. He said, why did the other guy get $500,000 and I didn't get $500,000? See, so it's all communication and paper trail. Right? It's effective communication. If you can't communicate, then that whole exercise, coming back to this voluntary separation, it will fail. So you need. I think you remember that Tabung Haji case I did. They did a separation, and then 2 years later there was another separation exercise which had a better formula. Those who took the earlier separation said, "Oh, you didn't tell me that you're going to do another exercise which had a better formula, and therefore I would not have taken this one. I would have waited 2 years to take the better formula." So they went to a civil court. Of course, civil suits, you have 6 years to file. Of course, they were not successful because it was a very well-worded separation exercise. So the court said, listen, you signed off, you can't backtrack. There's case law, the Zainon Ahmad case, the Bernas, so there are many cases on point, right? So, well, that's my 2 cents word on this point now. I'll hand you back to Daman.
Yeah, if I could just add on a little bit, so I think that was right. You see, sometimes it's tricky. Let's say we say 1.5 months for each year of service. But if the employee has got 2 years, that works out to 3 months. That's not exciting. So I know of some employers, when they have these kind of exercises, they have a few formula, and one of it will be minimum of 6 months. So even if you're there for 1 year of service, there's a minimum of 6 months in terms of a package. And Dato talked about retirement. So if someone has got 25 years of service, but 10 months to retirement, I would think potentially paying him 10 months and maybe a little sweeten another 2 months would be fine, instead of having to go on a per year basis. So it's not a science, I would think, and going back to this, the art and science, right? And Dato spoke about communications, which is what I'm going to be talking about a fair bit later. That is as critical as the quantum as well, a lot of the time.
Okay.
I totally agree with you. It's an art. Even conciliation is an art, right?
Yeah.
So if you don't have it, you can't do it. Yeah.
So VSS, MSS, good options. You get better money or offer, right? But given the current circumstances with the current economic condition, I think most companies would choose the route of retrenchment, correct? So
I think so.
Given
Supra, can I just stop you here, because I'm glad that Daman, you're in this forum, because I don't know whether you face this, but I have a lot of people who seem to think that there is a difference between an MSS and a VSS, right? But I always say it makes no difference. It is a voluntary, however you call it, right? I always take this statement by one of my good friends who was a HR director, Dato Hamida in CIMB. She referred to MSS as masa sudah sampai, your time is up, right? So, at the end of the day, because some people say, well, I'm dealing with a group, it's voluntary separation. If I'm dealing with an individual, it's mutual separation. I said, it makes no difference. At the end of the day, it is still a separation, voluntary in nature, however you phrase it or coin it. Daman, can you just see whether I'm on the right track?
Yeah, I totally agree. I think it's just a rose by any other name. Ultimately, it is some form of compensation in exchange for someone leaving happily, lah. So yeah, there's this notion about MSS is individual, VSS is a group. I don't find that to be a very realistic distinction. The principle is the same. Am I happy to accept this money to walk away and basically waive my legal rights?
Sorry, and a lot of people get caught by this because you know that you need the borang PK, the PK form, right? This is a statutorily prescribed form under the Employment Act, right? It's called pemberhentian kerja. And in that PK form, there are many. It doesn't necessarily mean termination. It also captures situations like reduction of salary, working hours, voluntary separation, right? So some people say, no, this is a mutual separation, so I don't need to fill up the form, right? So I have actually been quite concerned about this because I have some of my clients who go to the labor department. He says one person, you don't need to fill a form. But I can't find, Daman, correct me if I'm wrong, I can't find anywhere in any provision of the act to say if it's less than 5 people, you don't need to fill up the form. If it's more than 10 people, you need to fill up the form. I have not found anything. Correct me if I'm wrong, Daman. Is there anything?
You're right.
Yeah. So I always say, tell my clients, in abundance of caution, fill up the form.
Yep.
Because you don't want to be the first to be charged or taken to court. I've not seen anybody. Have you seen anybody being taken to court or taken to task for non-compliance with the borang PK?
I have actually.
Oh, okay.
We had one.
Okay. Yeah.
Over to you, Supra.
Okay. Now, let's go into retrenchment. Okay. Since at this juncture, I don't think companies can really afford VSS or MSS, and especially the small, medium-sized businesses, and they are badly affected as well. So, in a retrenchment exercise, if a company wants to undertake, how do we actually prove that the retrenchment exercise that I'm undertaking is a genuine case and it's not something I'm disguising just to get rid of those non-performers or the people who's got disciplinary issues? Sometimes it does happen, companies does do that, but how do I then prove that this is a genuine case of retrenchment?
I do believe Dato is going to speak about that, but generally, right, you see, this is where if you look at the law also, the first requirement is that there was some genuine reorganization. So you would, if you look at the classic proper cases of retrenchment, it would be because of some trigger. It could be financial loss. It could be outsourcing. It could be automation. And these things are generally demonstrable. When you don't have this kind of a thing, for example, today, if Top Glove were to go and do a retrenchment because of financial reasons, they're skimming money there. Now this time they're booming there. I remember reading last week, I think they're almost same price as Maybank already. So you see, it's got to be, and you'll get caught out because the industrial court is a court of equity and good conscience. So in good classic retrenchment cases, and I'm sure that's what we'll talk about in his part, you will have demonstrable evidence as to why the shrinking of the workforce was necessary. Normally, it is negative reasons, it's financial, economic, and so on, but it can be a positive reason. Automation, company may invest millions of dollars in new machinery, which then makes it many roles redundant because the machines can do those roles. So, but again, it has to be demonstrable.
Okay, thank you, Mr. Daman. Dato, you would like to add anything to that?
No, I agree with I agree with what Daman has said.
Okay.
In that there could be various reasons, right? You don't have to. I did a matter for a public listed company many years ago. The company was doing well, so the reason was not because they were in financial difficulties. They basically got a third party HR kind of expert to come in to look at how they operated. it's like when you go in for an X-ray, and my witness did very well because he actually articulated his case like a human being, right? He says, listen, there are times when you're perfectly fine, and you say, listen, I'm just going to go for a medical checkup, right? And then when you go to a medical checkup, the doctor says you got fatty liver, you got to stop drinking, you got to stop smoking, you got to do this, you got to do that. So similarly, what they did was they got this company to come in to look into the operations. And to cut a long story short, the independent third party evaluation of the system, the operations was that there were too many layers. There was too much fat. So, like what he said, I have to now lose weight, right? I've got fatty liver. My waistline is more than what I should be at my age. So I've got to lose weight. I've got to uh, stop drinking. So what the company then did was they basically, in this report, it basically said you have too many layers. A reports to B, B reports to C. So they de-layered. They took away one layer because there are too many reporting lines to achieve the same end result. And I'm pleased to let you know we actually succeeded because quite a number of them, not everyone took us to court, but those who took the people who took us to court didn't succeed because the court said, listen, yes, you can reorganize at any time. We go back to the basic principle of the Ong Lian Pek case to say the right to reorganize is a management prerogative, and you can reorganize at any point in time, good time, bad time, right? Because you are running your business. So, like what Daman had rightly pointed out, automation is one of the factors. You may be doing well, but once you have spent considerable amount of money on automation, right? Your workers become surplus to your requirements. So you can do it anytime, yeah. It's just that the process must be well thought over because, again, the courts also scrutinize the process. So if you don't do it right, you can't just wake up one day and say, okay, that's it, you out, 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 right? There must be some kind of um, uh, preliminary documentation or some kind of meetings. So I always tell people, always document, set up a task force, get board approval, right? To at least kickstart, to show that it was a well thought over process. Because you must remember, taking somebody's livelihood or terminating somebody, right, is a difficult decision, and the courts will not be very happy if it's just done arbitrary like that. So if you have a process, and again, of course, the times are good, you must also embark on cost cutting measures. I think Dam, you're going to touch on that, all that, right? Yeah. So we won't go into that. Perhaps Daman can tell you on what are the, because he's going to talk about the steps before bringing the matter to court. So perhaps maybe I'll stop here now and let Daman.
Thank you, Radu, for that cue on the process. So now we will go into part two of our discussion and presentation. I'd like to invite Mr. Daman to present on the what, how, and why, and when on retrenchment exercise within the organization. That technically is like what you need to do within the organization pre, during, and post a retrenchment process. Okay, Mr. Daman?
Thanks, Supra. Could I get my slides on, please, guys? So just to set my session up, on the art and science of retrenchment, I'm going to be focusing on the art because my aspect here is how to win the heart and mind of the employee who is retrenched, such that they decide not to go and file a complaint under Section 20, right? So if I can move on to the next slide, please. So again, I'm focusing on how we can increase our likelihood or the chances of an employee not triggering the Section 20 process, and so that everybody's on the same page. Anytime an employee has been dismissed, they can file a complaint under Section 20 of the Industrial Relations Act, citing that the dismissal was without just cause or excuse. So the question that I posed there is, what is the trigger for someone to file a complaint under Section 20? So what makes that person decide, right? And if you can move to the next slide, the answer is within Section 20 itself, in my opinion. Now, if you read Section 20, and I'm not going to read it word for word because, typical legal language is designed to confuse. Basically, it states where an employee considers, and I've highlighted that word, considers that he has been dismissed without just cause or excuse, he can trigger the process. So really what we're talking about is the perception of the employee who's been dismissed. That is the trigger. So I guess, in short, I can say that if an employee perceives how he was dismissed or the steps that were taken which rendered him to be dismissed as negative, if they perceive that as being unfair, they're not happy with something, that's the trigger point right there. Likewise, I've had many experiences where in some cases the companies have paid termination benefits following the Employment Act, which is very minimal. It's either 10 days wages per year of service, 15 days or 20 days. But the process was so well managed that the employee did not perceive it as negative. The employee accepted it and moved along. And so they don't decide, hey, you know what? I want to take this company to court. Really, it comes down to the consideration of the employee, and that's all about perception. If I could go to the next slide, please. So managing perception. How do we do this? I will distill this down to two things, and Dava spoke about it earlier. Communications, absolutely key. A strong communication strategy is possibly the biggest mitigating factor to try and reduce the chances of an employee perceiving the dismissal as unfair. And when I talk about this, I'm talking about the narrative. What are we going to say? And again, a lot of times the situation that the company finds themselves in speaks for itself. Like today, we're in COVID situation. Employees would already know the company is not doing well. So if the company is financially distressed, having a strong narrative about what to say, about who to say. You see, again, Dato talked about it earlier, when he used the example of dengan duka cita. Really, if someone who applies for a VSS and doesn't get it, what I would advise employers when they have a VSS, and I'm straying a little bit, is if I know that I want to keep Mr. A, even when the VSS process is open for an employee to put up his hand, I would empower my line managers to sort of tap the shoulder of Mr. A and say, hey, buddy, I need you, man. You are strong. Even if you apply for this, I'm going to say no. So you twist it to a positive, right? So, and that requires not just the narrative, the person who is conveying the message needs to know how do you convey this. So what to say, who to say it. Some people are better than others. There needs to be some scripts. There needs to be some training for the people who are going to be the communicators. How do you say it? Again, choice of words, have empathy when you're talking about a retrenchment. Understand and accept that this is not going to be easy for the employee. Share the fact that you wished you didn't have to come to this. And of course, the when to say it is also important. If you look at cases, and I'm sure that we'll talk about this later, the longer you give an employee time to digest, process the information, there is a higher likelihood that they're going to walk away without thinking about filing complaints and so on. The more sudden it is, out of the blue, he's coming into work, he's thinking that it's going to be a normal day, and he's hit with the communication saying, you're going to be dismissed. In some cases, they say you're retrenched, and today is going to be your last day. We will pay you salary in lieu of notice. Perception has been completely mismanaged. Even if you put in 1.5 months per year of service, that guy is going to think, this can't be right. I come in today and they asked me to give back the card. I had a case where the employer did it this way. And, the employee had to pack his stuff, carry it into the car. And then somebody was waiting at the car park outside because he's also got a car park tag. So he's got to tag it and give it out. You talk about mismanagement of perception. That's how you do things wrong. So the what to say, the narrative, who does it, choice of right words for the how do you say it, when do you say it, all of this becomes so crucial. in managing perception. And as Tava mentioned, you've got to think about this in detail. You need to have a strong communication strategy, and that requires preparation. The second very important tool on managing perception is fairness. Number one, this is the non-negotiable, full compliance with the law, right? So understand what are the benefits that you have to pay, whether it's in the CA, whether it's as per the EA, or whether you have a handbook or a term in your contract. Very important to treat everyone with respect and dignity. So again, giving them ample notice, dripping the communication. So you have, best way of doing it is there's an overarching communication upfront saying times are bad. We need to tighten our belts. So people already have a sort of insight that something might come up. And then incorporate best practice wherever possible. I will talk a little bit more in detail later. This is about career transitioning. So an employee is going to lose their job. Fine. Give him some advice on how to manage his life moving forward. Financial advice. There are some great career transition providers out there. They will come in and tell you how to manage your financials now that you don't have a steady income. What other options you have. Embellish their CVs. Get people to come in and try and help them improve their CVs. Some companies, they will even provide what is known as an EAP, an employee assistance program, which is employees have access to psychologists, clinical psychologists, to manage their emotions. So these two are the most important perception managers in my experience: strong communication strategy and fairness. If I could move to the next slide, please. You've got to understand your obligations, right? So on top of the strong communication strategy, you need to think about your execution strategy. Understand your obligations, understand your risks. So what are the legal and contractual obligations for notice of termination? Is it 1 month notice, 2 months notice, 3 months notice? For employees who fall within the scope of the Employment Act, even if their contract says 1 month, you're obliged to provide the notice as per the Employment Act. What are your obligations in terms of termination benefits? Again, consider, do they fall within the Employment Act or not? Do you have a trade union? If you have a trade union, what's your relationship with the union? If your relationship is good, all the better. If your relationship has not been great, you got to roll up your sleeves and embrace yourself for tough discussions, but you got to think about how you're going to do this. Check out, if you are unionized, what are your obligations under the CA? And I specifically am referring to 2 obligations. One obligation is about notifying the union. Most CAs will state you need to inform the union ahead of time. The CA then will have other articles which talk about the quantum that's payable. So understand that. The next point that I put there is identifying the people who are going to be impacted. This is so crucial, and that's what Tava talked about, the airlines restructure. We worked together. I remember there was a couple who both worked in the company, and both were impacted. And the senior management said, you know what, I'm not going to do that. We'll make it a guiding principle that if both spouses are working with the company, we'll make sure that one remains in employment. Things like, if the person is a single mom who has got a challenged child, learning disabilities, think about that. Include that in your thinking process. This is really how you can undertake a great retrenchment exercise if necessary. Now, when you do all of these things, you've got your communication strategy, you've looked at a strong execution strategy. What happens here is the outcome of this would be you have a clear and precise execution plan, and that tells you the different timelines that you ought to follow. Yeah. Next slide, please. So it's very important for a lot of considerations to go into it before you press the button. An extra month, yes, it might cost you more if you look at it from that perspective, but you might end up saving a lot because you avoid going through this costly affair of going to industrial courts and so on. However well you do your preparation, I always tell my clients, documentation. I've got this sort of a joke. If you talk to real estate agents, they will tell you, if you want to make money in property, there are 3 rules: location, location, location. You buy in a good location, you will sell at a profit. Likewise, you buy at a bad location, you're probably not going to make a lot of money. In IR, it's documentation, documentation, documentation. Why do I say this? The gestation period between a dismissal, between the last day of employment of the employee and your day in court, the trial, takes between 12 to 18 months, sometimes even longer. I can guarantee you that we will forget what we did, why we did. We'll be helter-skelter about trying to find out where the documents are. Dato talked about board meetings, the minutes of the board meetings. So the board actually sat, deliberated. You've got a great piece of evidence, but either you didn't document that or you've lost the documentation. Along the process, witnesses may leave the company. So if you don't have a witness and you don't have the document, how are you going to discharge your burden? Remember, in the industrial court, the burden of proof for retrenchments lies completely on the employer. It is the employer that has to prove the legal requirements to convince the industrial court that dismissal was with just cause or excuse. I cannot overstate how important to have everything documented. The more documentation you have, the better. You put yourself in the shoes of an industrial court chairman. If an industrial court chairman sees minutes of board meetings, looks at the selection process completely detailed, looks at the town hall session slides, looks at the one-to-one discussions minuted, gets to see the career transitioning program that was given to all employees, what type of trainings or what type of courses it has. So when they are inundated with all of these things, they are going to gravitate towards, you know what, I think this company was really fair. Documentation, documentation, documentation. I can't say that enough. Can I move to the next slide, please? And I'm sure that Tawa will talk about that in great detail. I don't think I've ever found myself in a situation where I said, oh, that's too much documentation. But more often than not, I find myself in a situation, how come we don't have a document for this? Even emails. Today, courts accept emails. Now, if I go through the procedural steps, as Tawa talked about just now, it's best practice if you could implement measures to make sure retrenchments are a last resort. So some cost-cutting or austerity measures that the company has done, things like freezing recruitment, minimizing overtime, certainly not talking about, you shouldn't be having grand gala employee engagement sessions where you go to Langkawi and spend loads of money to engage employees. It doesn't jive with your story if your narrative is that the company is suffering losses, right? Selection of impacted staff. This I will be talking in some detail thereafter. The selection of impacted staff becomes really crucial. You need to spend, and employers need to spend a lot of time to ensure that the selection is done robustly, fairly, backed up by documents or evidence which suggests that the reasoning for the selection is sound. Again, I stated here, every step of the way, please document decision making. So for example, what I'd like to see is prior to a retrenchment exercise, you've got emails from, say, the HR director saying, guys, we have got now a directive from the senior management and board that there is no recruitment except for jobs which are absolutely crucial or except in cases where people have resigned. That's a great piece of evidence. So, and you've got a document to prove that as well. Tawa talked about the Borang PK. You've got to notify the labor office. It's done in 3 stages, 30 days before the retrenchment, 14 days, I think Borangs 1 to 4 is 30 days before, then Borang 5 is 14 days before, and then Borang 6 is 30 days after. Consult employees. Tell them what's happening. I do believe that with proper communication, people have the ability to understand the situation. People have the ability to accept the situation, provided there is consultation, early warning, clear communication strategy that trickles down right from the top. It's the shock effect that, in my experience, often pushes people into thinking, hey, this is not right. I want to take this up. Of course, you've got to have retrenchment letters prepared. Termination benefits, typically it's pegged to years of service, but as we spoke about earlier, sometimes if you have an employee who's only got 1 year in service, it'll be nice if you could have a minimum of 6 months, right? Facilitate tax exemptions. The law, the income tax laws in Malaysia allows for termination benefits to be exempt from tax up to 10,000 ringgit for each year of service, right? Now that is today they've decentralized it, so each employee needs to go and get their tax clearance from their local tax office where they open their income tax account. But the company needs to prepare the CP22 form, explain to them what they have to do, right? So all of this shows the company to be a caring company and trying to help the employee yield more of the termination benefits and not pay as much tax. Career transitioning services, including the employee assistance program, which I touched on, such a strong mitigation tool. It really, in my opinion, gets employees' mindsets to shift from the past to the future. What's my career looking like ahead? I've seen career transition programs which brings in people who are insurance agents, very good insurance agents, to talk about what life is like as an insurance agent, how much of money you potentially can make. Real estate agents coming in talking about that. Unit trust agents. You get someone from DBKL coming in talking about how do you get a license to operate a garage, because people might think, let me take this the compensation that I've got and maybe I want to try a business. The last exercise we did, we even had someone coming in to give them training on online platforms, using online platforms to sell whatever skills you have. And there was a success story there. Someone became a CV writer, fantastic writer, I'm told. And apparently now he was, the HR director said he got in touch with that person and gave him some context to write CVs. And he was saying, I wish I had done this 10 years earlier. So that career transitioning services really helps employees to shift their focus from the past, which is the retrenchment. Let me forget about my previous employment. Let me look forward. And this is what makes people decide consciously, you know what, I don't want to take my company to court. I've got my compensation. They've given me some wonderful options here. Let me explore these options. So these are some of the procedural steps that you want to take into account before you go in. I'm talking about the pre-court, the court part that Tava will talk about. If I can move on to next slide, please. The potential minefields, the two areas that employers end up having loads of trouble typically is, number one, is the role impacted truly redundant? And I think, Supra, you asked the question about this. To me, there must be clear and demonstrable evidence to show this. And definitely there should be no replacements for that role. Because if there is a replacement, you're shooting yourself in the foot. It's clear evidence that the role is not redundant. So the requirement in law is that the person impacted, that role has to be redundant. And the more clear and demonstrable evidence you have, the easier it is for you to feel these areas in court if it goes there. Now, so redundant roles is a little bit easier. So if it's outsourcing, let's say security is outsourced, so the company doesn't hire any more security guards directly. Every security guard comes in through security call. So that's clear, the role is redundant. But in other cases, point number two is where there is a reduction of role. I used to have five finance clerks, but now due to the downturn in business, we don't have that many invoices to not so many invoices to send out. Collection has gone down, so I just need 3. So this is where the first issue is, why is there a reduction? Again, must be demonstrable. So there must have been something that has happened which makes it possible for you to continue running that department with 3 people as opposed to 5 in the past. So again, number of invoices, things like that, which are tangible. The more important aspect is selection. So if I've got 5 people today and I'm moving to 3, 2 are surplus to requirements. So how do I select that? The selection of the 2 to go and the 3 to stay becomes key. Again, this has to be demonstrable. What are the reasons I chose these 3 to stay and those 2 to be released? And typically you look at years of service, the issue around LIFO, which I'm spending a fair bit of time hereafter. You have in the Employment Act, they talk about foreigners go over local. If you're looking at performance, you need to have performance records. Any other reasons, special skills, you need to have demonstrable evidence to show why the person staying has got that special skill compared to the other. I'm conscious of you, Supra, coming back on screen, so let me try and speed up and go through my slides. Could I go to the next slide, please? Now, one of the big issues is about LIFO, which comes in from the Code of Conduct for Industrial Harmony. And I'd like to look at the quote here. This is the quote that the Minister of Human Resource commented at the point the Code of Conduct was introduced back in 1975. Clearly states, the commitment of the signatories is voluntary. Its sanction is moral. What does this mean? The Code of Conduct does not have legal force. It is a best practice. By all means, please try to comply with the code if you can. But one must not forget that this does not have the force of law. If I can move on to the next slide, please. So I think LIFO really is the issue that comes to bite employers and employees. Again, like I mentioned, this is in the code. I've already gone through what the Minister of HR commented. The last point on this slide is it's important to note that LIFO only applies where there is a selection. If the role disappears altogether, please remember that LIFO is not relevant. So like in a situation of the example I gave you of outsourcing of security guards, there is no selection. We're not selecting some guards to stay and some to go. In that instance, LIFO is completely irrelevant. LIFO remains relevant where there is a selection. If you could move on to the next slide. You know, I find there's too much of emphasis being placed on LIFO in courts today. I give you another reason why the value of LIFO should be distilled somewhat. This is from the Code of Conduct itself. And it states the employer should select employees to be retrenched in accordance with objective criteria. Such criteria, which should have been worked out in advance with the employee's representative or trade union, may and not shall. So these are not absolute rules. And if you look at it, point number 3 is consideration for length of service. One would argue that if LIFO was the most important thing, the draftsperson of the Code of Conduct would have put that as number 1. Instead, number 1 is the need for the efficient operation of the establishment undertaking. Rightly so. If the company is distressed, that must lead the decision on selection as opposed to LIFO. The second thing, ability, experience, skill, and occupational qualifications of the individual workers required. That is put ahead of LIFO. But if you look at industrial court decisions, sadly, LIFO seems to be the beacon of everything that is in the mind of the industrial court judges. I totally understand and respect that someone with more years should be given greater security. But when you're talking of retrenchment, it is the success of the company moving forward. We are in an operating theater, you know, it's the survival over everything else. And if I can go to the next slide, please. And you've got cases on this point. I know that Ottawa is going to be talking about it. Mahmood Copper Mining, which I believe Dato's former partner from his previous firm was the industrial court judge. He said the employer may take into account efficiency, proficiency, and trustworthiness of the employee. When the rule of LIFO is departed, there must be reliable evidence. Now, that's important. If you're not going to follow LIFO, it shouldn't be done willy-nilly. It should be done for a particular reason, right? Likewise, the court in Equant Integration, the Court of Appeal also said that. The Court of Appeal, if you look at the part underlined, how would the breach of the code affect a redundant position in the company? So the court was saying if the position is redundant, the code largely becomes irrelevant. But having said that, I know that LIFO is a killer for employers in court. So you need to be super mindful about if you're going to depart, please have strong reasons documented, demonstrable in court. Next slide, please. I would also like, this is my last slide. Today we have the employment insurance system. It's very important to me. Employers have already paid for it. You can have access to the EIS. You know, I'm not going to go into the details. Please use this because it benefits the employees. Employees can get certain benefits from this. They get some allowances. You've already paid for it. So this is another mitigation tool. It shows that the company is thinking about these employees, even though I've decided to let them go. So coming back to it, guys, how do you stay away from court? It is your treatment of the employee. And that is largely driven by strong communications, treating people fairly. That's what I have for you today. Thank you.
Thank you very much, Mr. Darman. That was really very informative. Now I'd like to move to part 3 of our program, Okay, and we'd like to invite Datuk Tawa to present and discuss on the what, how, why on mitigating and managing a claim for unlawful dismissal due to a retrenchment exercise. Welcome, Datuk Tawa.
Thank you. Thank you. In fact, Daman, you've said everything. I really don't know what else to say, but never mind. I've got to at least go through my slides. Can I, with your permission, just put the first slide to trigger some memory? Just look at the first slide. Okay. All right. Okay, so basically, which I've said earlier, the right to reorganize is a management prerogative, and in this, the courts generally don't interfere unless mala fides or bad faith can be established. So in this case, the industrial court, the judgment of the court was whether I'm just going to quote the principles of reorganization. Basically, it says whether retrenchment in a particular case is bona fide, good faith, or otherwise is a question of fact and degree, depending for its resolution upon the peculiar facts and circumstances of each case, right? It is well settled that an employer is entitled to organize his business in the manner he considers best. Okay, so end result is you decide how to run your business, right? And of course, as an employee, you say, who are third parties coming and telling me how to run my business? Who is the union to tell me who to select, who not to select, how to run my business? Correct? But it all changes when the matter is referred to the industrial court. When it goes to the industrial court, the court has the power to scrutinize the whole process to see whether on the peculiar facts of your business or your industry, you have done the right thing. You have the retrenchment is justified and the selection process is proper. So basically, you as a litigant or as the respondent company at the industrial court, you have two hurdles to clear. Number one, you have to convince the court that you have indeed that you had a right, or you had a reason to reorganize. As I mentioned earlier, in my earlier discussion with Daman, I'd mentioned that a client of mine at that time was doing very well. Financially, they were a public listed company, no financial losses. But as a result of them doing sort of forensic or analysis of their HR functions, they discovered there were too many layers, right? So they had to delayer. So again, you must be able to justify why you are revisiting your manpower requirements. So once you have cleared that hurdle, right, then you move to the next step, whether you have selected the right persons. So it's a two-stage test, right? Two-stage process. Number one, you must have the justification to reorganize. Once you've done that, at least the court, so like as in the current circumstances, I would say the court will take judicial notice of the current, the pandemic, the economic downturn for employers to reorganize. So this is the best time actually for employers to embark on reorganization, right? You can call it right sizing, downsizing. So some companies right size when things are even when things are going well, they just right size, right? Some companies downsize when things are not going well. So it's a question of choice of words. So can I just move to the next slide to see? Can you move to the next slide, please? Okay. So how do you justify a reorganization? So these are factors, right? So downturn, of course, is one main ground. Financial losses. Some companies hive off the operations. Sometimes you've lost business. A major client of yours has decided to pull out, and therefore you have lost that part of the business, right? And then you've got a reduced turnover or profits. So you could still be profitable, right? But it has reduced drastically. Assuming your profits were like 10 million and now 1 million, right? You're still profitable, but you're still justified in revisiting your manpower requirements because of that decline, that drastic decline in the numbers, right? So the courts will still look at it favorably. Of course, some people say you're still making profit, so why are you disturbing the workforce? But if you can show that the end result would still mean that if you don't take action now, the next year things may get even worse. So that is one ground: reduce turnover of profits. And of course, contracting out. Some companies contract out certain positions, so therefore the department, like say for example, if you have you contract out your payroll. So in your HR or IR department, you have various sections: training, personnel, and then you've got payroll, right? So some companies hive off or contract out the payroll. So the people employed in the payroll section would be surplus to your requirements. So these are the main areas where the courts would see some form of justification on the part of the employer in reorganizing its business, right? Which would subsequently lead to a right sizing or downsizing, right? Can we move to the next slide, please? So financial losses, I just given some example. What are the burden is of course on the company to prove financial losses. So the courts usually would look at your audited accounts, and basically you will have to prove actual losses as opposed to paper losses, right? And then reduce turnover or profits. The drop in general turnover, which sometimes will trigger the reevaluation of your manpower requirements. But this is a bit more difficult to prove. I find that when you are still profitable, very hard to convince a neutral party to agree with your decision to let people go, right? Then you've got hiving off and contracting out. Okay, this of course should not be when you hive off. Some organizations, by regulatory requirements, certain positions have to be there, like in banks and all that. Certain positions cannot be for security reasons or for certain statutory requirements. They can't hive off certain essential or core services of the organization. So there is a limitation to this hiving out or contracting out work, right? Next slide, please. Just take you through quickly this before I go into the case law, right? So what is retrenchment? Basically, retrenchment in that William Jack's case was defined as discharge of surplus labor, right, or staff. So Darman and I did one exercise where there was actually a complete closure, and retrenchment won't, I mean, when you talk about retrenchment, you're dealing with surplus labor. That means there's still going to be people left behind. So the people who have been let off will then challenge, saying, you are still running the business, there are still people left behind, and I should not have been let go. My work is still there, or my work has been undertaken by somebody else, right? So therein lies the difference between a complete closure and a retrenchment. Complete closure, everybody goes, no issue. So maybe later you should ask this question, but when you have a retrenchment benefits clause, would it be applicable in the closure? And I know Daman will be able to give you the answer there. Next slide, please. Okay, so this is part of another old decision where, in the context of defining retrenchment, the court has held that it is not the law that redundancy means the job or work no longer exists. Redundancy situations arise where the business requires fewer employees of whatever kind, right? In the case, of course, in this case, the judge held that the company's case was that there was reduced work and reduced business, which made the applicant's position as an executive director in charge of one group redundant, right? And the court, the industrial court, is right when it held that the applicant was indeed redundant. This is a decision of the High Court upholding the decision, the award of the industrial court. Okay. Next slide, please. So on redundancy, in the Bayer case, the court held on redundancy, it cannot be gainsaid that the appellant must come to court with concrete proof. The burden is on the appellant to prove actual redundancy. So basically, the ball is in the employer's court to prove redundancy. It's not the employee's job to do that, right? Or the burden is not on the employee to prove their case. The burden is on the employer, us. Next slide, please. So, of course, Daman has already talked to you about how you manage and how you to handle the pre-retrenchment issues. But when it goes to court, the court always likes to see what have you done before you actually touch the employee's position, right? So things like whether you're frozen or limited new recruitments, restricted working hours, avoiding new purchases, acquisitions, restricting overtime work, all these factors. I've just plucked it from various cases where the courts have used this, whether you've frozen new recruitment. So it's very important that in order to convince the court, you must have the paper trail. And the paper trail in court is crucial because that's how you establish your case. That's how you capture the attention of the judge, right? That you have documentary evidence to show how it all started, what triggered the exercise. Why did we have to do this? So I think Daman and I worked on one matter where there was an accident, right? An explosion which triggered the necessity to reevaluate the manpower requirements and the business direction, right? So all these things have to be captured. You have to compile and collate this because when it goes to court, ours is an adversarial system, so we go by the best evidence rule, right? So not only the documentation is important, but the presenter of the documentation, right? The person who's going to articulate your case is also key. You can't bring in a person who doesn't know what's going on or who is not privy to the documentation because then the court will not give much weight to what he or she is going to say on behalf of the company. All right. Okay, so move to the next slide, please. Of course, we talked about prior to the retrenchment, you must give sufficient notice to the Labour Department, the union, statutory notices. The reason why I tell you all this is, you see, and when it goes to court, in a Section 20, it's quite straightforward. The aggrieved workman says, I've been unfairly dismissed. You go to the industrial court, you have to prove your case why you retrenched, right? The justification for the retrenchment and the selection process. Why did I select him, right? Was he within the last in, first out? Or if I've departed from the last in, first out, whether I have the necessary justification. But you also have situations where in a retrenchment exercise, the collective agreement expressly stipulates that the company must do X, Y, Z, consult the union or pay certain benefits under the collective agreement. And they can also file a Section 56 non-compliance, right? This is separate from the unfair dismissal, right? So the wording of the collective agreement is also important where you need to study so that you don't get exposed because once you sign a collective agreement, then you're bound by the terms of the collective agreement until a new collective agreement is signed. So if there are certain provisions of the collective agreement that are not complied with, the union or any aggrieved employer can also file a non-compliance under Section 56. So you could be faced with a Section 20 unfair dismissal claim. You could also be faced with a non-compliance under Section 56. In addition to that, if you fail to comply with the Borang PK, for example, then you have another issue, a non-compliance issue, where the Labour Department can basically summon you, or I think I've quoted the section as Section 99A. And in this regard, I have not seen any of my clients who's been subjected to that, but I think Dam has mentioned that he has a situation where there was non-compliance with the PK. Perhaps after this, Dam can explain or give us, enlighten us on what happened there. Next slide, please. So, when it comes to court, as I said, you have to present what you have already got. You can't create a story because you are bound by your pleadings, right? At the industrial court, the aggrieved worker or the union will file a statement of case stating, that blah, 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 when I joined and why I was unfairly dismissed and I seek the remedy of reinstatement. The employer will then have to rebut the same by filing in your defense or the statement in reply. So that's all. You don't plead evidence. It's just facts. Now, where do you derive these facts from? As a lawyer, I would need to have a look at the documents, right? I can't rely on hearsay. I can't. The guy, your HR manager can't come and tell me all these things, and I put it in without it being substantiated. So I would require the paper trail, the documentation. So when it comes to retrenchment, one of the key documents that the courts always look at, because you know what they say, a picture paints 1,000 words. When you have a document before the court, it's easier for the judge and the panel members to better appreciate the facts. So to me, the organization chart is crucial because it is an easy document to show the court what the organization looked like prior to the retrenchment and post retrenchment. So if you are saying Mr. X was in this position, and this is the org chart in 2010, and this is where he sat in the org chart. In 2015, when we did the retrenchment, now we are in court. This is the current org chart. His position is no longer there. So easy to understand, easy for the court to basically look at the positions and see how the role has transformed from pre-retrenchment to post-retrenchment. A lot of employers have this problem in that they do not have this org chart. So when they come to court, they are put in a fix because the court says, listen, do you have an org chart? And then some of them quickly say, okay, this is how it looks. But it is not convincing enough because, as I said, we go by the best evidence rule in court. So what is important is it's crucial for you to, at the time when you're undertaking this exercise, please date the organization chart, date it with all the names and make sure it's accurate, because you don't want to have a situation where you're faced with the court saying that the left hand doesn't know what the right hand is doing. You say this is the org chart, and then the workers say, listen, this person had left the company 10 years ago, but his name is still in the 2010 org chart, right? He left in 2000. So ensure that the org chart is accurate and dated. So when you have the post-retrenchment org chart, the org chart to establish that the role and position is no longer there, that also should be dated, so it's easier, right? Then, of course, evidence of losses and declining profits, your annual report, your auditor's report you must have the actual audited accounts, because the lawyers on the other side will always want the source documents, right? And then the email, any email communications or company announcements regarding the reorganization, evidence of cost cutting. I had one case where the company had said, okay, as part of the cost cutting measures, we're also no longer going to give you a Milo in the pantry and no more newspapers, right? And we actually managed to find in that company's one of the drawers notice which basically confirmed the position from HR saying that as part of our cost cutting measures, we are sorry, no more newspapers in their lounge, and no more Milo and biscuits for this period. So I know it sounds trivial, but it's still a factor that would strengthen your case, because you have the employer has a difficult burden to discharge. You have to convince the court, right, that the employee's dismissal was with cause. So all these factors and documentation will certainly support you in the end result. So of course you don't want a situation where the left hand doesn't know what the right hand is doing, in that you take all these cost cutting measures, but your CEO goes and purchases a brand new Mercedes-Benz or a BMW, right? And then the union or the aggrieved employee puts a picture of the car parked in the lobby and says, listen, they're saying all these things, but guess what? Look what is parked at the lobby now. So you must make sure that you maintain a consistent stand and not be put in an awkward position like this. All right. So you also need to identify. If you see in my slide there, I said identify potential witnesses to support all the above. So who can be the best person to talk about the org chart? You don't want to bring a HR manager who was not there at that time, right, to talk about an org chart. So we have situations like that. Of course, sometimes the HR manager is left and the new person comes, right? So, of course, if you can procure the attendance of the person who was at that material time there, easier. And that can be done by cooperation, seeking their assistance, or in a worst case scenario, issuing a subpoena to compel their attendance. But it is very important to get the right person who is able to articulate, because otherwise the lawyer on the other side will just ask the employee, listen, were you there at that time? So you've not seen this document until the matter has been brought to court. And the guy will have to honestly answer in that fashion, and the weight to be given will of course be much lesser. All right. So always identify the right witness, and also the witness who can speak the language, because I've had cases where they've identified witnesses and the witness is unable to articulate in court. So very important, identify the right witness, go back to the source document, who are the people involved in that, and if the witness is more familiar in the national language, then put it in, because I've got cases where the letter is drafted in English, right? But the witness is not familiar, and the witness says, listen, I'm not very proficient in the language. Somebody has done that for me, you see? So these are the kind of situations that employers are faced in terms of getting the right witness. Okay, can I look at the next slide, please? Okay, so when we talk about when you talk about the selection process, once you've established in court the reason for reorganization, then comes to the selection process. Now, you may need to call different witnesses for different roles. The HR director will come and say, this is what this is a letter I issued to everyone. Standard letter saying company doing badly, you have been selected for redundancy. But the HR director may not be in a position to particularly talk about one particular guy. That person could be working in, say, the on site, and his supervisor is the one who selected. So you may have to call the supervisor to confirm why, especially if you're departing from last in, first out, for example. Why are you departing from last in, first out? People doing the similar work, you've chosen the guy who has a lesser length of service. So again, you must have the paper trail. The superior must come and explain why he chose this person. And if he says that this person is always on medical leave, or has got disciplinary issues, or whatsoever other grounds to support the departure, you must be able to produce cogent evidence to support that. So if you say he's a poor performer, you must have some kind of documentation to show that he's a poor performer. Otherwise, the court is not going to buy your story why you departed. Okay. Sorry, I'm moving very fast because I know we're running out of time. Then we can keep some time for questions, right? So last in, first out, I think you know the process is basically people doing similar or like work, right? It's the category test, and the courts usually go by that, unless you can show. There was a landmark decision of the industrial court in the Malaysian shipyard engineering case against Mukhtar Singh, where the court accepted the company's justification in departing from last in, first out, where they took certain factors, objective selection criteria like medical report, disciplinary records, age. But age is actually quite dangerous, because I always say, you must remember, when most of the people who sit and decide cases, they're not young, right? So if you go and say, oh, I chose him because he's old, I don't think you'll get a very happy look from the person hearing the case. So actually, age is something that I find difficult to convince. But if you can show competency, again, competency, what is competency? If you have hired a person for that role, and now you suddenly say he's not competent, you will have a problem. So there's a lot of companies now with automation and change in policies. They have now started doing reviewing positions in the context of fit to role, whether this person is fit to the new role. But again, you must also have a proper process to undertake before you can establish whether this person is fit to role. Because the aggrieved employee will say, you hired me for this, and now you're suddenly changing the goalpost to say, I don't fit the role. So why did you hire me last year, and now you say I don't fit the role? So again, there must be some kind of justification as to why the company is moving to a new direction, and why is the employee being required to be reassessed to see whether he fits the role. So the paper trail again is very crucial. Okay, can I just move to the next slide, please? Yeah, so this is what I mentioned earlier, the last in, first out, the Mukhtar Singh case. Okay. Next slide, please. So I just want to give you some examples. This case I did for Chevron. I lost at the industrial court. We succeeded at the Court of Appeal and the High Court and Court of Appeal. Just to take you through the next slide, please. It tells you the facts of the case. So here, basically, following a reorganization, it was a global reorganization. The position, claimant's position, was deemed redundant, right? And the company actually offered him alternative positions, which he declined. But of course, the alternative position he declined because he said the grade was lower. And then he was terminated and was paid a severance package, right, which he had accepted on a without prejudice basis, right?
Hello? I think we're having some technical glitch. I think Datu Tawa has dropped off or disconnected. Can we get him back online?
Becky? Can you hear me? Sorry, Zubra?
Yeah, I can. Right now you're live again.
Something went wrong with my it's okay. So I'll use my phone. Something went wrong with my computer. Yeah. Can you all see me?
Yep, can.
Okay. So, where was I? So talking about the Lim Chai Hock case, right? And he had served the company for 15 years. Last position was sales manager, finished lubricants in Malaysia. Can you move to the next slide, please? So the company's contention in this case was that the lubricant business to which the claimant worked in underwent a reorganization exercise to make it functionally efficient, right? Because it had not been meeting targets for the past 2 years. And the reorganization was in line with the lubricant businesses, right? The business groups in other locations. So basically Thailand and the Philippines. And at the material time, the existing structure of the lubricant division was not able to meet the aggressive growth plans and targets which had been set for the next 3.5 years. Right? These are the facts. This is what we contended at the court. Can you move to the next slide, please? So, what the reorganization entailed, the company's contention was the splitting of the claimant's position into two different channel managers, right? Direct and indirect, which was basically one grade below. And of course, he was offered one of the two newly created positions, right, which he declined. He was of the view, why should I take something lower, right? So his argument was, my role is still there. Yeah, you have split it into two, but it is still in the organization. So I cannot be surplus to your requirements, right? Of course, in that case, the claimant was not the only person affected, as the coordinator cluster marketing position was also made redundant. Can I move to the next slide, please? So the industrial court actually ruled against us, right? And found and basically held this, right? The court finds that the company failed to show that as a consequence of the alleged functional inefficiency of the lubricant division in failing to meet targets, there was a necessity to restructure and reorganize that division. So when you make a statement that triggers the reorganization, you must be able to support that statement. So in this case, we said it, but the court basically was not convinced. The court said, you have basically failed to show us on that functional inefficiency, right? So the court held that a redundancy situation did not exist at the time of which the claimant was retrenched, and basically the court found that the company had failed to prove the reorganization of the lubricant business division had resulted in the fact that the claimant's functions, duties, and responsibilities ceased or diminished, right? Even though the claimant's position at sales manager Singapore had been eliminated. So in that case, the position had been eliminated, but the court said you have basically failed to prove that the functions, duties have had ceased or diminished. Next slide, please. We took the matter up to the High Court, right? I'm still reading the judgment. So he said it is the finding of the court, although the position that the claimant had been eliminated, his functions and duties and responsibilities continued to exist and were carried out by two new employees. So this is the kind of problems that we always face. They still say it's still there, somebody else is doing it. Okay. And the court made reference to the Otis case, where it was said that whilst the court is mindful of the right of the company to reorganize its business in the manner it thinks best, the right has to be balanced with the right of the workman to security of tenure in employment, right? And the court made reference to the Ben Mayer against Tunku Nazrin case. Okay. Next slide, please. So in the matter before the court finds that the company had failed to prove that it had made a reasonable decision concerning the necessity of the purported reorganization that had the effect of rendering the claimant redundant, right? In the circumstances, the court finds that the company has failed to establish on a balance of probabilities that the retrenchment of the claimant was bona fide, in the consequence, inevitable conclusion that company has failed to establish that there was a dismissal with just cause and excuse. Next slide, please. Sorry, I'm using my handphone because my computer has gone out, knocked out. Okay, so in our judicial review application at the High Court, these were our grounds. We said that the industrial court had erred when it failed to take into account the fact that the applicant's right to reorganize is a management prerogative. That's our first ground. And our second ground was the industrial court had erred when it acted on an incorrect basis of fact in deciding that the first retrenchment, the claimant's retrenchment was not bona fide, although there was proof and witness testimonies before the industrial court to support the exercise. So we actually brought witnesses to confirm how the exercise was done. We put in the org charts before and after, right? So we said all this the court ignored. We also said it erred when it failed to take into account the relevant consideration that our witness had given evidence for the reasons behind the reorganization, right? So it's not that we didn't have grounds, reasons. Next slide, please. The fourth ground was that the industrial court had failed to take into account the relevant fact that the applicant's organization chart. Now, this is crucial. That's why I say very important, have the org chart, preserve the evidence. The org chart that was produced during the hearing was concrete evidence that the position no longer existed and therefore redundant. We also argued that the industrial court had failed to take into account relevant fact that the claimant's position was not the only position affected, right? And impacted by the reorganization. There was another position that was made redundant. So we did not basically, he was not the only one who was singled out in any way. And the next ground was that it failed to take into account the evidence and testimony of the company's witness that had shown that the applicant's various functions, job responsibilities had diminished because the role had been split to two smaller roles. And all this was brought in through a witness who was the company's witness. If you look there, it says COW1. Okay, next slide. The next ground, we said that, of course, basically the court had come to an unreasonable decision. And I'll just move on to the next. Can you just move on? These are all the main grounds that we raised. Of course, we talked about the severance package and that we had also offered him alternative employment that he rejected. So we said, there was good industrial relations. We complied with good industrial relations practice by offering him alternative positions. Of course, he was saying, why should I take an alternative position which is lower, right? But again, we still put forth all that to show that this was done according to process and with the attempt to preserve the employee's employment with the organization. Okay, next slide. Just move on to the next slide, please. So basically, the High Court overturned the decision of the Industrial Court and basically held that the inherent right as an employer and its management prerogative to decide the policy, strategies, and requirements before its restructuring exercise. So the court basically recognized the management's inherent right, overturned the decision, and they subsequently appealed to the Court of Appeal, and that also failed. Right. So this is just one example of what I say is very important is to have the right witness, the person who can articulate. I'm not going to take you to the other two slides because we're already coming to time is running out. So I just want to give you this one example that at the end of the day, you must have the paper trail, you must have the justification, you must have the right witness. So the company's witness was able to basically sustain the cross examination by the claimant's counsel, right? He was able to articulate and answer questions that were put to him. He was able to address the situation pre-retrenchment, post-retrenchment. There was documents there to help him. Because if we didn't have documents, then it'll be hard because it'll be hearsay. The lawyer will say, so is this just your personal view or how did you come to this? So just to conclude, what I want to say is when it goes to court, please make sure that all the necessary documentation pre-retrenchment and post-retrenchment are compiled, collated, and kept. Ensure that the right witness is called for the right document, because if a person who doesn't know anything goes and tries to put forward the company's case, he will have a tough time being cross-examined, and the weight to be given to his testimony will be less than what a witness who has direct knowledge or direct access to the documents will be able to do so, right? So I think I will stop there to let you all put some questions to all of us.
Thank you, Dr. Tawa. Can we have Daman back? Okay, the first question here is the Code of Conduct for Industrial Harmony enforceable as it only says it's a guideline and lacks the legal force?
Okay, can I answer this question? Because there's a recent case which I discussed with Daman. If you just look at my last slide, a very pertinent question. I look at my last slide. I think this case was also reported in the Free Malaysia Today, I think, just last week. If you could just look at my last slide, please.
I think they're trying to bring up the slide. Probably take them up.
Sorry, they're bringing up the slide.
So the case is a technique case. It's called basically it's Chang Seng versus Technip, right? The Court of Appeal basically overturned the High Court decision. The Industrial Court found in favor of the employee. The High Court, I think, overturned it, and the Court of Appeal overturned that. But the last case, number 3, the last slide. Oh, number 4, maybe number 4. Okay, this is the recent court, right? So basically, in this case, I'm just quoting what the court held, right? The court basically found in favor, the Court of Appeal overturned the High Court decision and found in favor of the employee, reinstating the award of the Industrial Court. So the court says this, while the Code of Conduct may not have the force of law, right? This is a crucial statement here, right? It is still the gold standard by which a company's action may be measured against to see if the whole exercise of the retrenchment had been carried out bona fide, and that every attempt had been made to explore alternatives before termination on account of retrenchment, right? While the Code of Conduct is not statute law, it nevertheless has some legal sanction as a document that the Industrial Court should have regard to when making its award, as clearly spelled out in section 30, subsection 5A of the Act, which says as follows, right? In making its award, the court may take into consideration any agreement or code, right? So I think Daman had taken you all through the code earlier. Now, as an employer, sometimes it's a bit hard for you to offer alternative employment. Tomorrow, if you are retrenching, say, your IR manager, what other position can you offer him? Can you say, listen, I try and offer you, our finance manager has left, I will offer you the finance manager's position, right? When you hire a person for a particular job, right, it's based on a particular expertise, competency, and you pay a salary that will commensurate with his experience and competence. So it would be hard for you to then say, listen, I can't, your position has disappeared from my structure, so now I'm going to offer you this position, right? Would it make so? The question that we have to ask ourselves, I think you would have to look at the peculiar facts of each case. Daman, would you agree with me? Even though, I mean, this is there, but you would have to look at the peculiar facts of each case, the position of the employee, before you can even attempt to make that alternative employment. Because sometimes the guy will say, listen, you are giving me an alternative employment which I won't be able to do. After 2 months, you'll probably sack me for incompetency, you see?
I agree totally. You know, the facts of the case are important, but I mean, sometimes I think that the size of the employer plays a big part. So, you know, like Technip being such a large employer, they probably will say, hey, there must be some alternative rule. You know, so these are examples that the code clearly does not have the force of law, but it is, the court here use gold standard, and I think that Ottawa probably has heard it so many times. I've heard it so many times. It's the go-to principles that industrial court gravitate towards law.
Thank you. Okay, next question is specifically to Mr. Daman. The reality to reductions in headcount is a combination of access to business needs, costs, and low performance. Because now in COVID-19 times, okay, and especially companies can no longer afford paying a premium to release people, regardless of communication. Employees are looking for a golden handshake. Appreciate your views on this.
Okay. The combination of access to business needs, cost, and low performance, right? Okay. Honestly, if you're going to go down this route, I would say that it's about trying to find middle ground. And I think trying to find middle ground, you need to be backed up with some evidence. It's like I said, today, Dato talked about it as well. You're probably best placed to have these kind of discussions because the realities are made known worldwide. Everybody knows the situation. I would say again, you know, that employees have the ability to digest the information in the circumstances, provided they are communicated in advance, treated with respect, dignity. And yes, people will be asked, I mean, you know, if you want to go down the MSS route and or VSS, whatever you may want to call it, the package, they want a handshake, golden handshake. It's about also talking about affordability and getting that message across in a credible way, getting the message across in a reasonable way to say, if we had more, we would like to give you more, but this is the best we can do, and trying to win the heart and the mind of the employee.
Thank you, Daman. Next question is, for employees not under the Employment Act, do we need to seek approval from JTK on the name list of employees we are going to retrench, or just proceed to retrench and submit the PK form later?
Yeah. The PK form.
Yeah, the PK form doesn't distinguish. It says all, you know, it doesn't talk. Yeah, so
correct.
It doesn't, because I think the government actually wants this for statistical purposes also, right? To know how many people are doing what, right? So I don't think the PK form doesn't, it is actually a global requirement. Everyone who is going to be retrenched, you're going to cut the pay, you're going to vary the working hours, you're going to voluntary separate, do voluntary separation exercise, you have to fill up the Borang PK. It doesn't say only those within the scope of the Employment Act.
Correct. I would want to correct the question. I mean, the question says, do we need to seek approval from it? It's not approval. It's
No,
notification. Yes,
notification,
but you
correct.
must do it for everyone, and please comply with the timelines. I've got a case where the timeline was not complied with, and the company had to go to court on it.
Okay. Thanks, Dato'. Thanks, Raman. Next question. If the retrenchment involved employees from different states or branches, would LIFO still need to be used? And employees not impacted will need to be transferred to a different state.
Okay.
Daman, you want to take?
So yes, okay. So involving employees from different branches, again, as Dato' made it very clear just now, we're talking about a like for like first and foremost. So if the jobs are totally different jobs in different states, definitely not. Now, if the jobs are exactly the same, to me, I would look at it from a branch perspective first. If this branch is going to lose, let's talk about salespeople. So KL is going to cut down salespeople from 10 to 5. And Penang, let's say, for example, is not going to cut down. Do we have to join all of these people together and then do that? I wouldn't go as far as that. I would do it from a branch specific or state specific method rather than put everybody in. So if the state or the branch concerned is not impacted, then I don't think that those people, you see, because it cuts two ways. If Penang is not letting go of salespeople, but KL is, and now suddenly the Penang people are under threat as well, even though their branch has got no reductions in jobs. So there is an unfairness in both senses. So I wouldn't say that you bring it together. And I think, there is also this issue of, they call it bumping and so on. So bumping, I know they talk about different companies, not the same company, different branches. But the principle to me would be, if that particular location is reducing its staff force, it should be a standalone.
Thank you, Raman.
Can I just take it? So, another thing is it's how you operate. So you remember the case of the Sejati Motors against Peter Lam,
Yes.
where the company operated as a group and they move people around. So you got to be careful, because if you move people around, say for example, if I don't like you, right, I use my group transfer clause and I transfer you to a branch to Penang, for example, right? So I move you to Penang, 2 weeks, and you cannot say no, because there is a provision in the contract to allow you to be transferred, and as long as the transfer doesn't entail a reduction in salary, status, or benefits, right, you have to go. Failing which, I could discipline you for insubordination, right? And after you go there after 2 weeks, I say, oh, sorry, we're closing down the branch. So everybody in the branch goes out. He will say, sorry, follow last in, first out. You've operated as a group. You move people around freely, right? You can't now just suddenly look at the branch in isolation, see? So again, you need to check how you've moved people, how you operate, right? And have that conscious decision before you complete the selection process.
Thank you, Dato'. Thank you, Raman. I think this next question is for Dato' Tawa. Okay, in my experience, VSS or MSS, employees have a tendency to take employer to court, even though extreme care has been taken in conveying or carrying out either one. What is the general stand of courts? Daman mentioned documentation. With all the documentation in place, do employees run the risk of compensating over and above?
No, I think if you look at the case law, you just look at the latest Sirim case, which I did, very clear. The courts have, I think Daman was our, what's his name, Anderson's decision. Very clear. The court says, listen, the documentation is clear. The witnesses have explained. You have applied, right, voluntarily. And there in the Sirim case, even one thing back, they took one step further. They even had a cooling off period after the people were identified. They gave them, the board said, I give you 7 days to think about it. You can change your mind. So there was a cooling off period, right? And so, of course, the danger is when you don't give the person time. You say, listen, today briefing, tomorrow submit, day after I approve. In situations like that, the employees may turn around and say, I was forced, I had no choice, right? And then again, the language, your selection of witness. In some cases, you go and give a guy who doesn't understand, who doesn't speak fluent English, a documentation English, I hereby understand, herein, therein, therefore, all these things put there, a lawyer is drafted for you. The guy comes to court, saya tak tahu apa saya tulis, dia cakap ambil dan pergi, saya sign saja. Right? So, you must be able to I always tell my clients, if you're dealing with people who are not proficient in English, you have a translated person in Bahasa Malaysia for them to understand. So it clearly shows that the documentation process is also well thought over before it's executed, you see.
Thank you, Dato. I think we will take one more question as we are running out of time. Question is, can we retrench a person from the sales admin department at the same time recruit another new staff in the sales department? So that means you're letting go of an administrative person, but then recruiting a sales executive.
If the role is completely different, right? So it's not a replacement of the person who was let go because the roles are, I mean, it could be like in sales, you have the sales admin suggests that to me, they are doing the administrative part of the sales, sending out the invoice, doing the collection, as opposed to a sales staff who's going out and meeting customers to try and sell the product. So if the roles are different, it's not a replacement of one person for another, but you must be clear about that distinction.
Thank you, Daman. I think we have to take this question, all right? I'm actually being forced to accept this question. Okay, for those above the Employment Act scope, are they entitled to the termination benefit as spelled out in the Employment Act?
Okay. Let me start. I think, yeah, and Dato's former partner wrote a case law on, I mean, there's a case on his mom, actually Mahmud Copper Mining, but firstly, if you're outside the scope, you've got to look at your terms and conditions. If your terms and conditions provide for termination benefits, you will have to comply with that. But I think the issue here is, if there are no terms and conditions on termination benefits, this person is outside the scope, do you have to pay? Strictly speaking, no legal obligation. But if you look at the case, Mahmud Copper Mining, the industrial court chairman there said, it is good practice that you should be following the consistency. I mean, if you look at it from a fairness perspective, I am $1,800, I get it. You are $2,001, you don't get it because you're $1 outside. You know, it's I can understand where it's coming from, but purely from a strict legal perspective, the Employment Act Termination Layer of Benefits Regulations applies for those who come within the scope. But you know, there is that overarching, again, think about the reason, the trigger why somebody files a complaint. I am not going to understand why that I'm outside the scope because I'm 2001. So what am I going to do? Probably going to file because I'm going to perceive it as negative. It's a tough one. Legal answer, yeah, no, you don't have to pay if you don't have terms and conditions, but you've got to factor in the overall, because the industrial court is a court of what do you call that? They will look at these things, you know, and that's what happened in Mahmud Copper Mining. So,
Dato', anything to add before we close the Q&A?
Yeah, no, I think that's all. I mean, I think Mahmud Copper Mining, with utmost respect to my ex-partner, is a decision which was in the 90s, right? When I had lots of hair and black hair, right? So now the landscape has changed. Supra, I don't know whether you had hair in the 90s, right? But the landscape changed, and that was the industrial court decision. So I don't think we are bound by that decision. It's not. It is not.
agreed.
The superior courts have not ruled on this point. If it was a decision of the Court of Appeal or the federal court, then I would be concerned. But I think we can also distinguish, if you're not running a mine in East Malaysia, you may be able to distinguish the facts. Yeah?
Agreed.
Thank you, Dato'. Thank you, Daman. I would like to, before we end the session, like to welcome Mr. Sukhdev, the organizer of the event, okay, the CEO of EPLI, to just share with us a background of EPLI and a little bit about himself. Mr. Sukhdev?
Thank you, Supra. Good evening, everyone. Basically, Employment Practices Liability Insurance, or EPLI, is a HR risk management solution and employment insurance for Malaysian employers. The policy safeguards the interests of these employees against any wrongful dismissal claims that arises from an employment dispute. EPLI basically covers businesses in the event an employee files a case under Section 20 of the Malaysian Industrial Relations Act 1967 over employment-related issues stemming from wrongful termination, forced resignations, or even constructive dismissal. This is the first of its kind here in Malaysia, whereby EPLI Asia, Sdn Bhd, offers a 3-in-1 solution, whereby we educate, we advise, and protect businesses in the employment-related disputes. The financial risk of having to pay out is a bit expensive. We all know that. But here's the equalizer for the employers itself. With the EPLI insurance, businesses are covered in terms of the compensation that you have to pay rising from the court awards to the terminated employees and a predefined limit of the legal fees. This product is exclusively provided by EPLI Asia's neighborhood. So, for those of you who are interested, for details of the EPLI policy, do email us and your contact details to epliasia.com, and we will contact you as soon as possible. Back to you, Supra.
And thank you to EPLI. Okay. And I also like to thank everyone who has joined us today and taken your afternoon. And I hope we all have learned something valuable and ensure that we do not make mistakes at the same time and do it right humanely. I think the key is ensuring the retrenchment exercise is carried out fairly and humanely, okay, and legally, right? And I'd like to thank Datuk Tawa for spending the time with us and Mr. Daman, right, for taking this 2 hours. I think we are at 2 hours 17 minutes and sharing your knowledge and experience with us. Till we meet again next month, everyone, we'll be bringing you a series of exciting relevant issues as part of education, as part of our education series. In the meantime, follow us on LinkedIn and Facebook for constant update on the latest information on HR and IR in Malaysia. Till then, stay cool, stay safe, and always be mindful. Thank you very much. See you all.
Thank you.
Thank you.
See you.
Bye-bye.
Okay, that's a wrap.